Good afternoon, everyone. My name is Muhammad Ali. I'm a third-year student here at Stanford Law School. And on behalf of the Stanford Association for Law in the Middle East and the Muslim Student Awareness Network, I would like to welcome you to today's talk, The Quran as a Legal Text. Thank you all again for coming today. We have a very exciting lecture ahead of us. Just to give some background, this event was inspired by a growing interest within the law school and the general Stanford community over the last few years to invite scholars of Islam from a variety of disciplines who can speak knowledgeably about the religion and its role in the modern world. Today's topic will focus on the Quran's role as a legal text by explaining the sources of Islamic law and elaborating on several controversial Quranic verses and their interpretations throughout history. The lecture will last until around 1:45 and will be followed by a Q&A session. So I have the pleasure today of inviting Professor Abbas Kadhim, who was one of my mentors as an undergraduate at Stanford University. Professor Kadhim is a scholar of Islamic theology and Middle Eastern history. A scholar of Islamic theology and history, is an assistant professor of Middle East studies at the Naval Postgraduate School in Monterey, California. He has also been a visiting scholar at Stanford University since 2005. Before that, Professor Kadhim taught courses on Islamic theology and ethics at the Graduate Theological Union in Berkeley, California. Professor Kadhim received a BS from the University of Mosul in Iraq, an MA in Political Science from San Francisco State University, and a PhD from University of California, Berkeley. Professor Kadhim has published on a variety of topics, ranging from articles on the future of nuclear weapons in the Middle East to an examination of Ayatollah Sistani's clerical philosophy. He is also the author of a book published just last week by the UT Austin Press, Reclaiming Iraq, the 1920 Revolution and the Founding of the Modern State. And just for good measure, it's worth adding that Professor Kadhim wrote my recommendation letter for law school. So thank you for that, it worked out pretty well. So with that, please welcome Professor Abbas Kadhim.
Thank you. Thanks, Muhammad, for the great effort of making this work. Thanks to Stanford. Although I'm not unfamiliar or not stranger to the Stanford campus, but it's always great to be here. I guess the last goal is to give a talk at Stanford Law. That's the one goal that I have not accomplished yet. Leaves me no other goal, so once I finish from here, I will go home and write my memoir and retire. Muhammad is a living proof beyond a shadow of a doubt that it does not hurt you to take a class with me at any time of your career, and my recommendations sometimes work. It was an easy recommendation to make. Muhammad is wonderful to recommend and to work with. It's an honor and a privilege to be here. Thank you for the invitation again. I'm gonna speak on a few issues, and then hopefully my remarks will raise questions. It's not much of a lecture, more than just looking at it as a dialogue and a debate. I enjoy that more than one-way flow of information, or if you like to dignify it with the word knowledge, then I appreciate it. I will speak about the Quran, speak about the Sharia, speak about the Quran within the context of Islamic law, and then talk about the Quran and the Islamic law within the context of modern laws in states, constitutional law in the Muslim states, and then finally, with your permission and time's permission, also explore some examples of the Quranic verses and how they can serve as legal bases for certain cases or certain rulings, and the controversies from that, how the Quran can or cannot be decisive sometimes in coming up with a verdict or a ruling. So the Quran, it is very clear what the Quran is, but I will, at the risk of being simplistic, we'll talk about it a moment. The Quran is the revelation, a book that contains the compilation of everything that was revealed to Prophet Muhammad over the span of 23 years. 13 years while he was in Mecca, leading an underground religious reformist movement, a religion, and then after that, when he migrated from Mecca to Medina, he spent 10 years, the last 10 years of his life, building the city-state in Medina that successfully ended up, just by his death, expanding through all the Arabian Peninsula, today's world, probably 6-7 countries of today's world. So the Quran has all of that revelation text, if you will, that was revealed to Muhammad. The Muslim belief about the Quran that it is the exact word of God. Muhammad's agency in the Quran is no more than just a conveyor. He receives the word and conveys it to the Muslims as he received it. He does not rephrase it. The words are not his, and the meaning is not his. So he is a messenger, and to convey the message that was divinely revealed to him by the agency of the angel Gabriel. The other belief in Islam is that the Quran, not only that it is the exact word of God, but it is the authentic, 100% authentic, exact word of God. The Quran, in the Muslim belief, that it has not been altered or modified or tampered with by as little as a comma. So it is what we have here, with some controversies talking about certain possibilities, but everything in the Quran. There might be a talk about an omission of a word by some Muslim scholars, and these are controversies that Muslims normally deal with all the time. But the general consensus of all Muslim scholars are basically that what we have in this book we call the Quran is the exact revealed word of God. The Quran's content is not uniform in the meaning and the purpose. It is different than other scriptures in a couple of ways that I'm going to mention. One is that the Quran has stories, if you will, anecdotes about times past, about other prophets, about the prophet and his times as well. And also, so there's a narrative there, different than what you find in the Bible. If you go to see where Moses is mentioned in the Bible, you go to Exodus or you go to Genesis. But well, you know, Moses in the Quran is mentioned over 133 times all over the Quran in all kinds of, not in one place. The only exception here that I mentioned from a biblical story would be Joseph, where all of the Joseph story is in one chapter called Joseph. But Moses is certain parts of his life or glimpses of his life are mentioned in various places. The reason for that is that the Quran does not present its narrative as a form of a history or a chronology, but it presents this narrative as a number of lessons. The prophet is told at a certain time, you are in despair because they don't believe you. See what they did to Noah, see what they did to Jonah. And then at another situation, there will be a similar case from another prophet's life, and then you can assemble it and you find sometimes some kind of a biography of a certain prophet. The other part is what we may call the theology of Islam. If you go to certain verses and certain chapters in the Quran called surahs, you will find the theological teachings of Islam, especially the Meccan side, the early part of the Quranic revelation. And it's normal because Islam began in the beginning as some form of an anti-pagan theological revolution, so it began with the theological concepts. It didn't make much sense to tell Muhammad a lot about laws at a time when he had no domain to enforce these laws. That's why we see the laws in the Quran are revealed in the revelation of Medina, the last 10 years, when he was a head of state, a head of a society, and with a legal system and laws to enforce. Ethical teaching in the Quran is a lot. It's in the narratives that I mentioned of the Prophet. It is in other verses. So there is another dimension of the Quranic text that is the ethical part. There is also in the Quran the legal component. And it might come to some of you as a kind of a surprise to tell you that the Quran, which is the central nerve of the Islamic Sharia or legal system, it does not have many verses that deal with laws. With, again, differences among scholars about that concept as well. The Quran, which has over 6,000 verses, organized in 114 chapters. Some chapters are as little as 3 lines, and other chapters would have 40 pages long. But all of these over 6,000 verses, some scholars would tell you that there are no more than 180 verses really in the Quran that deal with laws. A very small percentage. That's one school. Some would go as far as saying it's 500 or so verses, while other schools in Islamic legal thinking say every verse in the Quran has a potential for a creative jurist to come up with it doesn't have to be a verse that says explicitly do or don't to be a legal basis, but any other verse for a creative jurist. It can be a basis for a certain ruling or a guidance for a certain ruling. So we are kind of between those two schools on how the Quran is being mentioned as a legal text. The Quran then is, when we mention that it is the basic or the central nerve for the Muslim or the Islamic Sharia. Sharia is one of the most misunderstood concepts when it is mentioned in the literature written in English. What is the Sharia? A lot of people, when they hear about the Sharia, they imagine heads rolling and hands being chopped. Sharia in Arabic, the etymology of it really means law. That's why I always smile when I hear someone says, so-and-so wants to impose Sharia law on us. Sharia law, if you put it in one language, it means law. Because the Sharia and law are the same. But the Sharia as a term, some would refer to the practice or the all of the laws we have on the books, so to speak, in Islam, to say this is the Sharia. The codes that are enforced by Muslim scholars for the last 1400 years. Another more specific and I would say more accurate definition of Sharia is that it is the text of Islam. The authentic or binding text of Islam, that would be the Sharia. All of the laws and the practices and the enforcements are the interpretations of the Sharia. Why am I saying that or endorsing that? Is because we see that the Sharia has been interpreted and enforced in various ways according to several schools. At least currently we are talking about 5 dominating schools. The Shia school, chronologically speaking here, the Hanafi school, the Maliki school, the Shafi'i school, and the Hanbali school. These are the schools of law. Now, if we understand by Islam that God intended only to give one Sharia and to have one set of instructions for every case, but Muslims have enforced it in various places in at least 5 ways, then we cannot endorse one of them to say this is one that meets God's expectations and the others are wrong. The good news in Islam, unlike theology, where if you disagree with them, they call you a heretic, an unbeliever, and they believe that you are destined to hell for doing it, which is okay if someone calls me an unbeliever that will be destined to hell, but it becomes a problem if they send me to hell prematurely. That is the next step. But the good news or the silver lining in the law, you don't have that. Legal differences, legal interpretations among schools are tolerated. In other words, if I would disagree on a verdict on the practice of Islam between one school and the other, that's not a basis, at least the vast majority of scholars, they don't look at it as a basis of being a heretic or an they call you misguided at best. That's, but not really somebody who is unbeliever, unlike the theological differences among Muslims. So the Sharia is basically the text and the textual basis of Islam, and then the interpretations are the schools that we see enforced in the last 1400 years. Now we have 5 schools. Some would extend it to 8 schools over the years or the centuries, and there are others that came and went away. The ones that stood to the test of time are the 5 that I just mentioned to you, and they gained number of followers. So what is the text that is making us the Sharia for us in the proper academic, if you will, interpretation or meaning of the Sharia? The Quran, and the other component of it is the Hadith. By Hadith, or the Sunnah, use it as a larger term loosely. The Sunnah referring to the tradition of the Prophet, that is his statements or statements attributed to him, if you were to be precise, and his actions or the actions that were reported as he has done, and his consent. That's when somebody says, I did this and the Prophet saw me and didn't say don't do it. So that comes as another. Now the authoritativeness of, or the authority of these 3 components of the Sunnah are not equal because of the how much weight each one has. When you attribute a statement to the Prophet, there is no doubt once you authenticate it that the Prophet meant that this is what needs to be done or what needs not to be done. But when you talk about the action of the Prophet, that would probably be open for more interpretation and more doubt. Why? Because we are looking at someone observed an action and how much of this action the person understood and whether the Prophet kind of conveyed everything by the action unlike by the words. Now when it looks at the consent, it becomes even weaker. Because who is to tell that this person was performing an act and the Prophet was doing nothing other than paying attention to him? Yeah, he did it in the presence of the Prophet. But maybe, so jurists normally look at these with different weight, the highest weight being to the statement attributed to the Prophet. That's the hadith in the narrower etymology of the word or the term. The difference between the Quran and the hadith is very important. The Quran, as I mentioned, in the Islamic understanding and belief, it is the exact unaltered word of God. There is no question about its authenticity. However, the hadith, which was written some 200 years after the death of the Prophet, coming to us down the decades and even the centuries in certain cases as an oral transmission from one generation to another, from one narrator to another. So and so told me, so and so told him, so and so told him, until you find someone who says the Prophet said. And these were all, again, not written, but they were heard from one person to another until they got to the person who decided to record it when there was this tendency to record the hadith. The problem of this, again, is clear to you. How many of you will leave here and get the exact words I said 20 years from now, saying, in 2012, I attended a talk and Kadhim said. Some of these were exactly like that. Someone who said 20 years later what they heard the Prophet say. There is a lot of at least authentication problem with the hadith. And Muslim scholars recognize that in addition to the needs sometimes for fabricating some of this hadith, and especially 100 years later when Muslims were divided into groups, political, theological, and how convenient it is to support your position by a statement attributed to the Prophet and if it passes. Indeed, some cases there were some good intentioned quote-unquote times for fabricating the hadith. One person was caught fabricating hadith and they said, why did you do that? He said, I see that people are staying away from the Quran and I thought if I make some hadiths giving people incentive to go and read the Quran, that would be good. So it's kind of nice fabrication, not really malicious one. But still, he made up hadiths. If you read the Surah Yasin twice a year, you will never be poor, or things of that nature. You hear some of that. And some of them, of course, it's fine to make up hadith that is ethical teaching or of some, reads, why not, reads, so. But some of them, if they are hadiths that are fabricated and they can be basis for legal action, that would be a big problem, because there is a hadith that, as the scholars would say, a hadith that necessitates the knowledge, and a hadith that necessitates knowledge and action. And the hadith that necessitates action is even more dangerous, and the damage is more when it is fabricated. So that is another kind of layer, if you will, of looking at the hadith versus the Quran. Muslim scholars have found ways to work with around the hadith, and whether it was acceptable, not acceptable, authentic, weak. And also there are the schools of legal thinking in Islam, the 5 that I just mentioned, and other scholars. Normally they look at them with different attitudes. There are schools that would, for example, abandon the work with a hadith, even if they consider it to be authentic or close to authentic, if they find a rational argument against it, or if they find that the well-being of the society will be served better by going to a different interpretation than the actual interpretation of this hadith. And that is a school, the Hanafis, for example, are one, versus the Hanbalis, for example, who would like to go with a hadith, even if it's weak or maybe borderline on a fabricated hadith, than to use any kind of reasoning or opinion for that matter, or any rational argument. A different kind of weight is given by different schools to the hadith. There is also this idea of practical convenience with the hadith. When you talk about a book called Sahih al-Bukhari, for example, there is a controversy here among the Muslims and also even among the schools of Sunni Islam on this idea of something being sahih. Because once you talk about sahih, authentic, then everything in it is authentic. But we know that there is some contradiction, there are some problems with the application of those. What are you going to do with them? And there are schools. Some would say don't follow it all, and some would say follow it all and find your way around that. That's why you are a great jurist. So it's very important to look at this. The Quran does not have all of that. The moment you see a text in the Quran, there is no question about it being binding. There is no question about it being authentic. But there is another dimension of trouble working with the Quran for the jurists over the centuries. It is the problem of interpretation. How are you going to interpret a text that is written in a language of the 7th century, and the author is not accessible, and the Prophet, who was the messenger that brought it to us, is not accessible as well, to ask him about the original meaning. Something here, I'm in a law school, something that is exactly what you deal with when you talk about the Constitution, the US Constitution. I mean, you get down sometimes to simple words. People who are smart, they go to Stanford Law or to Harvard Law or to Yale, and then they end up disagreeing on the meaning of the word arms. Okay, what is the arms? Is it the thing that Madison needed 5 minutes to load? Or is it the thing that can mow down 200 people in a matter of seconds? Would the word itself be qualified if they knew about the semi-automatic thing? Some would say yes, some would say no. There is no decisive answer, because unless you bring Madison and show him this and say, would you still hold this text the way it is? What do we have? We have interpretation, then, at best. Sometimes the Quran is silent on few issues, and that's why the Quran and the Hadith are augmented by other sources of legal processes. When the Quran is silent on something, then you go to the Hadith, and the Hadith is silent on the same issue. You have to go to precedent, maybe, or you have to go to reason. And this is, again, not different from what we find in the legal system of the United States. One example that you are all familiar with is this idea that to appoint a certain high official in the United States, the president would need the confirmation of the Senate. Well, when Johnson, in the post-Civil War era, he's the successor of Lincoln, as you well know, fired the Secretary of War. He was impeached in part about this. Now, he survived that fiasco of an impeachment, and because of his survival, the question was never settled. It took 4 decades later or more for the US to go back and also answer this question. The Constitution is silent. It says, in order to have a Secretary of War or any secretary, you need the ratification. It doesn't say to fire him you will need or you don't need the approval of the Senate. And it was 4 decades later, it goes to William Howard Taft, and William Howard Taft would say, well, makes a completely rational argument and then says the president, in fact, can fire a cabinet member or an appointee because that's the only power he has over his subordinates. Completely sort of rational argument, because he went to precedent and the only precedent that is there was a fiasco. The Constitution is silent, so he had to go to reason and look at what else that he could do to work. Muslim jurists will do exactly the same. They go to the Quran, they go to the Hadith. Then if they don't, they go to the to reason, or they go to qiyas, which is really it's analogy, and the analogy means that you are using a precedent. So in a sort of step by step, one of the things that I'm rethinking my recommendation to you is that you didn't have any water here, Mohammed. So now. Let's take a look at then the other implications to having the Quran as a legal text, which is this requirement, for at least popular requirement in modern today's states or modern time states that wrote constitutions. Mostly, of course, as we know, the Muslim land or the Muslim domain for until somewhere around middle 19th century. All of the legal system was based on the Quran, and the jurists are the judges, all of the juristic process was handled by the fuqaha or the scholars of religion. Your judge is your traditionally trained faqih, that is a scholar of religion. Then later on you started either in Egypt or under the Ottoman Empire having sort of the importation of French-based or Belgian-based laws, European, and then they began to work in mixed courts, and then later on, a little bit by little, it replaced the Islamic judicial process, except for a couple of countries that persist on them. Saudi Arabia is a well-known example, for example, and Iran in a sort of not completely, but in a certain way. Now that will require what? When you write a constitution, you have to have a saying about what Islam and Islam's role will be in your legal system. And this has been, thank you, Muhammad, this has been a case really that was always of a controversy. In fact, this is one of the things that will require more negotiation than anything else, and at least in the post-conflict countries. Iraq is a well-known example. The Egyptians until now are arguing over what this will mean. What do you say about Islam and what its role will be? Is it a basis for legal process, or is it the basis? This word, a basis versus the basis, masdar min masadir al-tashri' or masdar al-tashri' in Iraq, for example, it took them months to settle it. And then finally, they didn't really settle it. They had two items or two parts of the article. Each one of them cancels the other. One says Islam is a source, which means you can use other sources. Then the item after it, it says no law shall be passed that contradicts Islam. So in other ways, you can bring another law, but it has to also be accepted by Islam. So it really doesn't, you don't really know how that will work. Same thing the Egyptians right now are doing. Why are we having problem with saying that Islam is or putting Islam as a source in the modern legal processes? One is this situation here, is that you cannot really use the Islam only because we have, as many states right now have to deal with it. There are international treaties, there are international requirements right now that are not necessarily part of Islam or even in agreement with Islam, especially when you talk about international treaties and conventions on women, on POWs, on many other issues that probably Islam will twist it a little bit differently or handle it differently. That's one problem. So if you say Islam is the, means you have to throw away all of these or you cannot be part of them. Or if you are, then you violate your own constitution. The other problem that will be there is that what Islam is it? Okay, we already settled here convincingly that there are 5 interpretations of the Sharia. So what are we, which one are we going to follow? There isn't really a lot of, or there are not many cases where the entire population of a state are belonging to one school. There is always a mixed society. Even in places where one school is endorsed and imposed, there are people who do not belong to this school and they follow another school. So how are you going to deal with it? And that is a problem. In some countries, it was settled in a very clear way. For example, in Iran, they made it easy for everybody. They, right there in the constitution, they didn't say Islam is the religion of the state. They said Ja'fari or 12er Shia Islam is the religion of the state. So in other words, you go not to the Islam or the Shia even, no, it's one version of Shiism, and ultimately it is their own interpretation at home of what the religion will be. So here there is no problem for the constitutional scholar to deal with. It's one that is constitutional. But if you say Islam, then the question is it Shia Islam? Is it Hanafi Islam? Is it Hanbali Islam? Is it Shafi'i? Is it Maliki? What is it going to be? In another place, for example, like Lebanon, they solve it in a different way, where they have courts for the Shia and courts for the Sunnis. And good luck if it is, let's say, a case that involves a Shia and a Sunni, of course, then how are you going to settle it? And by the way, the relevance of that mostly with civil status laws. It's not really with death penalty for a murder or this. And mostly the penal code is settled according to one form of a state law, except for, like I said, in a couple of countries that don't have a modern day law, like Saudi. But in these countries, it is civil status law, things that deal with marriage, divorce, inheritance, child custody, all of these issues. How are you going to do it? And that is one solution that Lebanon, Bahrain until recently have been enforcing that as well. Or in another case, like let's say Iraq, for example, when they decided to pass a civil status law in 1959, their idea was to have a more progressive law for the state. Originally, there were all of this civil status law was handled according to the Sharia, in certain Sharia, whoever the judge would be. So they decided to have a more progressive, friendlier to women, friendlier to children, friendlier to the family in general. So, but they did not want to endorse one. Iraq has Shafi'is, has Hanafis, has Shia, and smaller other numbers of other schools. What are you going to do when you wanted to? If you didn't want to endorse one, then they found a very tricky way. They went with an interesting phraseology in it. One of them, it says, basically they are following the opinion of the majority of Muslim scholars. So whenever there is a consensus, we will follow that. But we also, when we look at the religious interpretations, we have to follow the ones that are prevalent in Iraq, or in a country whose religious legal thinking, fiqh, is similar to Iraq. In other words, a jurist in a court or a judge cannot go to the Saudi precedent to do it because it's mostly a Hanbali. No, they would go probably to Egyptian or something like that, where the Hanafi or Lebanese, where some Shia interpretation is allowed. But they made, sometimes when they wanted to endorse a certain interpretation, they had to go with not the religious guidelines, but they want to go with the original purpose of passing that civil status law is to be family friendlier to the women and to the family and to the children. So when there is a majority opinion that is not friendly to the women, and there is a minority opinion that is good to women and good to children or good to the welfare of the family, they would go with that. And if you are to follow that civil status law, you will see sometimes the Hanafis will win, sometimes the Shia will win. In some cases, for example, the Hanafis would say a marriage that is forced upon the women is valid. Once, I mean, you are not supposed to do it, but once you force them and the marriage occurs and there is a marriage, then it is valid and they go with it. The Iraqi law said no. They would punish for that and they would make it as a rule, a basis for separation at the request of the wife. At any given time later, there is no way you can say now it's too late for you to do this, for example. So here the Hanafis lost. In one case, in another item, when you look at the, for example, the age of the marriage. Here they went their own way. They said it's 15. Initially they made it 18 and then they brought it to 15, where some Islamic schools would allow it as early as 9 for the girl and 14 for the boy. So they made it 15, kind of in the middle, with the consent of the judge and parental consent, of course, not only for for marriage, if you needed witnesses or not. Muslims are not, there's no consensus. Some say you have to have witnesses for the marriage to be valid. And while, for example, the Shia and some Sunnis say it's not important. And even among the Sunni schools that require witnesses, they differ on when would you need the witness. Is it when you conclude the marriage contract or when you do the wedding night and the two people will be gathered in the house of the marital status is being consummated? That's a difference. So what the state says, you have to have witnesses. And sometimes they did not go with any school of law, and they went against them all. Inheritance, for example, they made it equal for men and women. No school of Islam would, because it's a clear case where it says the lot of the female is half of the lot of the male from the inheritance in certain cases. So basically you do not follow any of that. And this was a controversy that still exists in Iraq. The scholars of religion, especially Ayatollah Hakim, for example, at the time in 1959, raised hell for this ruling. And 40 years later, it's very interesting. History gives us a lot of lessons. When his son, Sayyid Abdul Aziz al-Hakim, became the 1-month president of the Iraqi Governing Council, the first law he passed was to repeal the civil status law of 1959. And luckily Bremer was around with a veto and vetoed that, the only agreement I have with Bremer doing anything in Iraq, and he saved that civil status law. Because they wanted to get rid of this idea that the women get the equal share of a man. In certain cases, there is not necessarily a contradiction with religion. When the state decided to say we will punish anybody who concludes a marriage contract outside of the court, okay? Islam does not necessarily say you should. It does not say you should not go to the court to do it. It's just an organizational issue. The state would like to protect the integrity of the marriage contracts and make sure that rights of the women and the men and the children down the road do not get to be in a vague standing. So they required a contract to be done in the court and a heavy fine for anyone who marries out of the court. Here you don't see necessarily a clash with the system of the religion and between that and the civil status law or the law. And then the same thing, you go with the criminal code and you go with the other codes in the nation, the legal, the legal process itself, how to make laws. Islam has something to say about it, or the economic part and the business, contracts and others. Banking, if you will, that's another issue with the interest is one of the central controversies in Islam, and how you are going to solve it. So there is every single law, you will see this similar kind of, the principle itself is either you have religion being followed literally, or, as in Saudi, for example, or religion, not just Islam, but one school, or there is this idea that you have reconcile different schools and go with the groups, or you simply, there are a couple of countries also, as Iran made it easy for themselves and adopted one to the detriment of others. Same thing with Turkey and Tunisia until the collapse of Ben Ali. They just did not even have a mention of Islam in their constitutions, and then the laws are 100% secular. So that's another take on it. But whatever the domain of the law, civil status, criminal, business, etc., structural legal processes, it is all having to deal with those obstacles. Now, let's take a look again on how the Quran is being handled by a jurist, and how does the jurist go about getting guidance from the Quran. Sometimes an issue that comes before a jurist and the Quran addresses it in a clear way, and it is very simple manner, you do not have much room for interpretation. The wording is very clear. Sometimes it is vague or open for more than one interpretation. And you would probably suspect, and you would be 100% right, is that there are no many cases where it is clear-cut. First of all, we are dealing with a 7th century language. Language has changed over the history. You are dealing with a text that could mean more than one interpretation. So it's hard, even with similar, with easier texts. For example, when you see a verse in chapter 2 of the Quran that says divorce can be made twice, and if he divorces her a third time, she cannot marry him until she marries another man. So in other words, a person marries a woman, divorces her, then marries her again, and then divorces her again, and then that's kind of where they will get the red line. You do it one more time, and you cannot remarry without her marrying another man, not for the purpose of going to the first husband, but just marrying an honest marriage, living with the person and that marriage honestly. Because some people would do it as a trick. In fact, there are even comedy films and things are made on how people are trying to find the servant and tell him, here is $1,000 and let's do it, and then sleep in the kitchen for tonight, and then tomorrow. No. You have to really, because it's a punishment, and there is no punishment in that. But even with this, so simple, marriage can be done twice. Third time she has to marry another man. Muslims found a way to go around this text and then argue. It's simple. They say, well, is it really 3 times where you marry, you live together, you divorce, you live away from each other, you marry, and then you do it 3 times? Or is it when a person is really mad, and especially this happens when you are, you want to watch the Stanford and Cal game, and your wife says you have to go and pick the kids, or let's talk about those, this bill that I found in your pocket. And you say, well, after that, no, I want it now, and one word from here, one word from there. It's not going to be one divorce. It will be like, you are divorced, 3 times. So make sure that she heard you well. Well, Muslims say that counts as 3 times, while others say, no. Once you said you are divorced, you divorced her. She's no longer your wife. How can you divorce her again while she is already divorced? And there is a controversy of this. The majority of certain schools would say no, 3 are not, they are 1. The Shia would go with that, a lot of Sunnis, while others say no, 3 is 3, and that you have to deal with this if you said you are divorced 3 times. And that's while it's a simple text, you will find a room for it. Sometimes you will find the issue visited in more than one occasion, or even in one occasion, but it is kind of murky. For example, in chapter 4 in the Quran, there is a place where it says God instructs you or guides you in matters of your children. Give, I mean, those who die, give the male 2 shares of the, or equal to 2 shares of the female from the inheritance. And then it gives you scenarios, because not everybody dies leaving 1 child and or 1 male and 2 females. There are all kinds of other cases, and there are people who inherit not just the children, the wife, the parents, etc. So there is a long list of scenarios in the Quran. But in the case where someone dies and leaves only daughters, for example, no man, the Quran says if it is 1, she gets half of the inheritance. If they are 2, or if they are 3, more than 2, in fact, the exact words, if it is more than 2, they get 2/3. The Quran is silent on 2, that's one problem. It doesn't tell us. If it is 1, give her half of the inheritance. If no other boy with her, a sibling, if they are more than 2, you give them 2/3. And it doesn't tell you what do you do with the 2. Now, some would go with the half for the 2 because it's closer to the 1. Some would say no, more 2 or more, you give them 2/3. So that's one. Then it gets even dicier when you will see how precedent worked, and then what do you do with what is beyond the half? And you know, if a person who dies with $200, that's not a big deal, but someone with a few $1 billion dying, okay, after you take the 2/3 away, there is 1/3 of $2 billion. Who is going to get this? And the Shia, for example, and some Sunnis would say it will go back to the daughters because there is nobody else who will inherit. While some Sunni schools would say, no, you give it to cousins and even those whom you never saw, you never invited or send them a Eid card or whatever, they will all bring their, take their tickets and they will come and they say, okay, give me my share. And that's a problem. What does this happen sometimes? It creates a dilemma, especially for those who have a lot of money, they have kids, and perhaps they don't care for distant relatives to give them money. There are true cases. Adnan al-Pachachi is one well-known story. This is an former Iraqi diplomat. He used to be he's a Sunni. He used to be a minister of foreign affairs. He went to the UAE, helped them set the country in the 1970s, made a lot of money. He has only daughters. What does he do? He registers as a Shia. Now, once he's a Shia, just nominally, and he says it right there in a TV. He said, I'm a Shia nominally. And because then, when he's there, then all his daughters will get all of the money he leaves. Okay? But the moment, he got, and you get that sometimes in this, and there are famous cases where people will become Shia just for one purpose, and then for the rest of it. Another famous case is when Pakistan, during time of Haqq, he decided to collect the zakat because he called Pakistan an Islamic state. The Shia said, no, we give our zakat to the Ayatollahs, we don't give it. He said, okay, the Shia are exempt. And you can imagine the numbers of the Shia in Pakistan. So that's another, you can get Shia, roughly speaking, in any country except for Pakistan, in those. But these are cases where you really force people, unless you find a decisive way to deal with it. But definitely, that's a controversy, even though the issue is addressed by the Quran. Another controversy that is always cited is this idea that a person, or in marriage, there is a marriage that is dissolved. There are various, if you will, scenarios why a marriage is dissolved. One of them is divorce. And the Quran says, well, in the case of divorce, the woman has to wait for a certain number of weeks, if you will, or months, before she can marry again to determine the issues of pregnancy, etc., and then ultimately parenthood. So the Quran talks about scenarios. One of them is those who are young women who can still are in the childbirth or carrying age. It says that they will have to wait for 3 periods. Okay, the ones who are not in childbirth age, either older or younger, still they are not at that, then it gives them a 4 months and 10 days. Or 4 months, excuse me. And then if in another case where the marriage is dissolved not out of divorce, but someone dies leaving a woman. So those, again, they will have 4 months and 10 days. But in another place where if the woman is pregnant already, the Quran says the marriage or the time of waiting will be when the marriage is, the pregnancy is ending. It's like, وَذَوَاتِ الْأَحْمَالِ, then it says, أَنْ يَضَعْنَ حَمْلَهُنْ, when they give birth. Which means what? If a person divorces his wife and she still has 7 months left, 8 months left, then she has to wait the 8 months, not the 3 periods of her monthly period. But if they are, in the delivery room and they start fighting, you are the reason I'm in this pain, and he says no, you, and then all of a sudden one word from her, another from him, he says you are divorced. 3 minutes later the kid pops out, she can marry. So it's not 9 months, it's not 4 months. Now, what do you do if it is not an argument and it's not a divorce and it's not a delivery room problem, but the person, 2 people love each other and then the person dies and his wife's pregnant? Now, is she going to be able to marry once she gives birth, or the 4 months and 10 days? Or some Muslims would say, if you put these 2 verses together, you will come with this idea that whichever is closer, just like the divorced woman, whichever is closer. If it's closer that she gave her birth, she can marry. Or, in other words, if she gives her birth, let's say in less than 4 months and 10 days, she can marry. If she gives it after, she has to deal with the idea that she has to wait until the pregnancy. The Shia, on the other hand, have a different way. They follow a verdict that was given by Ali, the highest icon of Shiism, as you all know, the cousin of the Prophet, who said, no, she has to do whichever is later, not whichever is closer. In other words, a divorced woman with a husband who is alive, she gives birth about a week later after the divorce, she can marry a week later. But a woman whose husband dies and she gives birth a week later or a month later, she has to wait for 4 months and 10 days. While if it is the 4 months and 10 days pass and she is still pregnant, she has to wait until she gives birth. So here, there is a big controversy. What do you do if you are the judge? In this case, normally they follow, as I mentioned, either they follow one, or they follow the one that is endorsed by the state, or they reconcile it with a state, with a legal precedent, or they will go as the Iraqis, they take the majority, or whichever they find as more friendly to the women. Another issue that would be mentioned here is this question, and I will close with it and then leave some room for discussion. This idea of adopted children. The Arabs, for a long time, until sort of Islam was coming, they used to adopt a child and they would give him their names, and the person will be called so and so, the son of, and then they say the adopted father or the adopted parent. In the adopting parent. Islam comes and in chapter 33 would say, do not do that. Call them to their own parents, or their own biological parents, if you use a modern day parlance. This is better. So you cannot call them. Indeed, the case happened even in the household of the Prophet. He had an adopted child named Zayd, and then people used to call him Zayd, son of Muhammad, Zayd ibn Muhammad. And then when the Quran came to this, then the Prophet told them, don't call him this. Now, why is this? In Islam, adoption is allowed as a practice, but they don't call it adoption the way we do it, and they don't give it the name of the... It's because of the kind of law Islam has. One of them is the law of inheritance, because in Islam, an adopted child does not inherit. You can leave him a will if you like him, but you do not And a person who dies in Islam is allowed to leave a will up to 1/3 of his property. Anything beyond third in the will not be endorsed or enforced. But up to 1/3, you can give him up to 1/3 of your will. It doesn't matter. But once the person dies and there is no will, he does not receive anything from the inheritance. It is the property of the biological children. He already got your attention, your love, you raised him, you spent on him, but beyond that, once the person dies, in other words, whatever is left behind him is not his property. You own only 1/3 of your property that you can leave as a will. Anything beyond that, it is not owned by you anymore. So what happens here is that you don't. The other part is incest. Okay, a person. If I go and get a child and adopt him, and I have a daughter, he can marry her. If we were talking about this person as, you get the same name, and also down the road when you look at his children and her children and how that will work. So there is the incest issue also that will be a murky issue that Islam will deal with. That's why they would not call this a child or a son of, but they call him an adopted child. And it was an Quranic injunction. There is no question about it anymore. People don't use it. It's not anti-adoption law, it is more of reframing the legal term and the legal relation between the adopted child and the adopting parent in that sense. I mean, there are hundreds, as I mentioned, of verses, but it gives you an idea on how these issues and the dynamics of the argument works in the text. So let me stop here and see if there are any kind of questions, follow-up. I will. I promise you an answer. It might not be the right answer, but you will get an answer. In that sense. Yep. Some people mentioned that they have classes. I understand if you have to leave. So thank you very much for leaving. Yeah. Yes, sir.
I'm rather partial to separation of church and state.
Okay.
It troubles me very much to have religious law become the law of the state. And I understand from your presentation that there are different schools.
Sure.
And some are very, very strict, narrowly defined. Other, Hanafi, I think you mentioned,
Yes.
more liberal. Nonetheless, if the Quran is the word of God, no commas excluded, and you're getting out of it directions or instructions about when you can divorce, that to me is a real threat. Can you respond to that?
Well, no, I mean, it's, like I said, I already presented this issue of putting Islam in the Constitution as a major problem that every society has to deal with it. For one simple reason, or more actually. One of them is, which Islam are you going to endorse? Because if you have 3, 4, 5, 6 rulings, then how are you going to enforce one, and what do you do for the others who don't believe that this is the right ruling? Second is that we are not sure that any of these 5 or 6 rulings are really God's intention, because these are interpretations at the best of judgment of that scholar or number of scholars who are making them. In that sense, you have to deal with it. There is the other issue that again, it will run again sometimes. What do you do if the interpretation itself is not up to the requirements of time? There are scholars who have interest, and then they are fine with changing their view or worldview about how to interpret a text on the basis of the difference of time. And there are people who are thinking that anything that was done after the 2nd century is really some kind of innovation that is not part of Islam. I mean, this is a major problem, and when you look at some Muslim schools that says the only authentic interpretation of Islam is the generation of the Prophet, the generation after him, and the 3rd generation. Anything else after that is not authentic. It is just some kind of risky practice of law interpretation. So I'm with you here. It's on the practical level, it is impossible to reconcile, you know, the only way to do with it, to deal with it, is really to find. I mean, I like the Iraqi law in a way, because what they did is they were very bold in that. They allowed certain things that are that have no problem being adopted, and when there is something that will end up with a law that is unfriendly to women, they went with a secular law. I mean, they weren't. I mean, nobody ever defied it to the level where saying here is a Quranic verse that says, you know, give 50% of the share of the man to the woman, and they right away say, no, we will give them equal shares. So that, in a way, you are, you know, kind of working with it. The problem with you know, separating Islam and the state business, it will run you into a problem with the population. Can you really survive as a state? Let's remember that, in part, what cost Abdul Karim Qasim in 1963 his life and the state and Iraq may be a great opportunity for development was that one law, I would argue. Because the moment he passed it, it was exactly like, you know, Lyndon Johnson signing the 1964 civil rights law. In that sense, there goes the South. So when he did it, you know, he said, there goes the Shia, because they were, and ultimately, he ended up with nobody other than the communists to support him. And if the communists are your friends in a Muslim country, good luck surviving. So, in a way, you know, there is the ideal that you mentioned, which is great. But on the other hand, you are dealing with a society that 80% of it, probably nowadays, you know, does not prefer to see some argument that is contrary to Islam right away.
If I could do a quick follow-up, but when we went to Turkey, we were hosted by a couple there who were very secular. I read some about the history of Turkey and how it had been more or less forced to become a secular society, and this had happened very, very rapidly. There's a great deal of paranoia with regard to those who are secularists about Islam being written into the Constitution and into the law, and I don't know how you see the influence in this country. It doesn't seem to me to be a major threat right now.
No, I mean, you know, the Turkey side that you just, I mean, the Turkey example that you just cited is a very important example within, and in fact, it's anomalous in a way in the Muslim world. The Turks consciously decided to, you know, use force to change the entire intellectual setting of the state. They even erased the entire memory of a population by changing the alphabet simply, you know. So you have, after 20 years later, and until now, you have Turks who cannot read books and materials produced in their own language 80 years ago or 90 years ago. So simply, you know, instead of having a book burning party, which doesn't look good, so you just make these books as well as, you know, as good as burned. And that's one part, and there is a whole. But you know, what happens in the last 20 years, after all of this forced secularization, all of that, you see a resurgence of endorsement for an Islamic party, and the Islamic party that came 12 years ago is not exactly like now. It's kind of incrementally is moving towards Islam little by little. Still, it is the silver lining in the Islamic political environment in the Muslim world. But you know, who knows where they will go if they get 2, 3, 4 mandates down the road with Turkey. Tunisia was another example where the state was completely secular. They had even more forceful, I mean, French kind of secularism, but they were toppled. And see what happens in Tunisia right now. The ones who are elected are another. Egypt, which was the one hope for the Arab world, for a long liberal tradition and long intellectual tradition, see where they are right now with the Muslim Brotherhood and the Salafis. Syria right now is moving also towards that. If Assad falls, Iraq already has been there. Every country that had a change. It shows that you cannot defy the population for a couple of reasons. One of them is that we did not have a long liberal tradition for it. Post-colonization ended up with changing colonialism with military rule that was basically corrupt and overreaching and overhanded or heavy-handed. And then you didn't have, so the alternative, the only one that got the sympathy was the Islamic model. But the problem is that it is not the Islamic model that you would like to see. It is not Islam of the scholars, it is Islam of the guys with guns in their hands. And that's why, it is a challenge, I agree with you. It is not going to be easy. I'm not going to sugarcoat it to you in any single way. It's tough. Yes, Bob.
I want to go to your title. I'm going to say in rather sharp form what I think you've been arguing.
Okay.
You can give a reverential nod to the Quran as the source of law, but as a matter of fact, as a matter of historical fact, the development of jurisprudence is the work of 5 schools of philosophy and legal
At least.
interpretation.
Yes.
And I could make the same kind of case about the emergence of Jewish law. There may be some sections about Jewish law in the Hebrew Bible, but many of those laws refer to getting yourself properly cleansed for sacrifices at the temple, which no longer take place. So a lot of that body of law is moot.
Yes.
The same is true for Christianity, because there were different notions. Even if you just stuck to Jesus' words, there are several different ethical precepts cooking there, whether you turn the cheek or whether you came within a fire or a sword. So one of the things I'm interested in terms of the way people talk about their loyalties and get attached to making a claim about their holy book in a way that makes them not weigh seriously how the book itself, however authoritative it is and however loyal people are to it, is only the stepping stone for what that society develops as its way of living, behaving, and trying to bring order. So I understand the kind of instinct to say, I stand with the Quran or I stand with the Bible. But as a matter of fact, you're really standing with the traditions that grew out of those books. Because much of what's happened and developed in your legal traditions and all other kinds of traditions are not addressed directly in your holy book.
Yes.
And an unwillingness, I think, to understand how religions necessarily develop every day. And the tendency of people to be fixated about talking about the primary or charter document as if it's all there is really a problem for modernity. And it's one of the reasons that a lot of people walk away from those systems. Could you please be honest about what you actually are? That's just a very difficult issue. So the Quran could be seen as a legal text.
Yes.
That's your title.
Yes.
You said Quran as legal text. Okay.
No, as it's a legal text.
But you demonstrated
in a way. But
yeah.
Here you are talking about it, not the Quran in its entirety, because as I mentioned, when you take the Quran, I'm interested in this idea or in these 2 schools where they will tell you that the Quran, there's only up to a 500 number of verses from 6,000 that can be legally informative. While there are those who will tell you, no, every single verse in the Quran, it's not only the ones that have orders and prohibitions that are legal texts, but every single verse in the Quran. I mean, and if I were to give you an example here, when the Quran talks about the duration of the pregnancy and the and nursing are 2 years. And then another verse that says women or mothers nurse their children for the pregnancy and the nursing are 30 months. And then it says women should or women nurse their children for 2 years. You can find this second one as a legal kind of text, if you will. That's how much a child is entitled to from his mother's milk. But when you look at the second one, it's not to say make it 2 years no matter what, and the moment it's 2 years, you know, it's not to decide or to determine how much the pregnancy is. But when you put these two together, as it happened in a famous case about 5-6 years after the death of the Prophet, they determined that the least acceptable pregnancy is 6 months, because you put these two together. Why? Because before that they made sure any pregnancy that gives a child that is living or alive less than 7 months, they considered it as a sign of adultery. So how did they do it? They wanted to stone a woman actually who gave birth 6 months after her marriage. And Ali ibn Abi Talib comes and says, well, you read these two verses. The second one has nothing to do with laws. You know, because Quran cannot legislate the time of or term of pregnancy. You let it go whenever. But at the end, you know, they take these two, and a text that is legal and a text that is not necessarily legal by itself, and then one informs each other and you get a verdict. So it's really, as I mentioned it, I would say yes, the creative jurist can be informed, can be guided by the Quran. But the question here is that, is the Quran the only text that gave us legal? It's this argument, a legal text or the legal text. That is definitely not the legal text, because we know, and you know very well from what I know from our talks, is basically, you know very well that you know, a lot of the time the legal process in Islam not only did not follow the Quran, literally sometimes ran against the Quran. And it is, the examples are there and it deserves a presentation by itself. You're right. Yes, one.
So I think we may need to wrap up this.
Okay, maybe one last question.
Sure,
then?
let's
One of the issues that many people have with Islam is that it's perceived to be very aggressive in trying to gain influence in other cultures and societies. So the question is, does Sharia place a requirement on Muslims to try to expand the influence of the faith? And if so, what methods of expanding it are considered unacceptable? And are there any methods that are considered unacceptable?
That is one of the huge issues that really have interpretations, and I think one could be informed by the practice of Muslims for 1400 years. And you know, I would kind of, again, this is my personal opinion, not how Islam and Muslim scholars see it, but my reading of it is that the Muslim state began with not a forcible and expansive state, and it turned into an empire after the death of the Prophet. In other words, what was done after the death of the Prophet is not necessarily what the Prophet have done. My evidence is, see what the Prophet did with Mecca. His city, it was the only thing standing between him and spreading his influence, both moral, spiritual, all moral, spiritual, and political on the peninsula. He could have done it literally in the year, probably the 5th or 6th year after migration to Medina. He had to wait 3 more years to do it, because if he did it 2 years or 3 earlier, he would have done it, but with a bloodbath. Ended up basically taking it in the 8th year after the Hijrah without killing one person, a overwhelming kind of decisive victory without having to do it. So, you know, while other Muslims were not that willing to wait for a long way. Now the Muslims, you know, to add to that, or maybe qualify it a little, the Muslims that expanded the Muslim state from the gates of Vienna all the way to the western borders of China were not religious fanatics, they were tax fanatics. So long as you paid your dues, you paid your taxes, they didn't care much what religion you practiced. Look at the Ottomans, who ruled over Eastern Europe for centuries, and Eastern Europe remained majority Christian. Look at the Arabs who ruled in Spain for 8 centuries or so. It remained a majority. Look at what India happened, 7 centuries or so. the majority of Indians remain Hindus. And same thing, they even extended to them the status of the people of the book, even though the Quran doesn't mention them, unlike Christians, Jews, and Mandaeans. Well, why did they do that? Is because they were not much into converting people. The only case of mass conversion with the state power for it was not from non-Muslim to Muslim, but from Sunni to Shia, which happened in the 1501, started in 1501 with the Safavids in Iran, and where, you know, convert or die, but not in the case of converting Christians or Jews to Islam in the magnitude that one thinks. So I would say that there are, you know, there is a model that was established by the Prophet. Then it was abandoned, but not very much, you know, not 100% abandonment of it. I think the Muslims after the Prophet were pragmatic and more expedient in applying expansion versus persuasion to that. That's the best I can say at this quick thing, but definitely there is more to be said about it. Yeah.
Okay, thank you everybody for
Thank you
coming.
very much. I appreciate it.